Hello everyone, my name is Kim Heinrich and I handle marketing for Meritas. I would like to welcome and thank all of you for joining us for today's Meritas Capability Webinar, 3D Printing, U.S. and Global Intellectual Property and Business Challenges. Our webinar today is scheduled for 60 minutes and will be led by today's presenters who are Meritas members from a variety of different regions. First we have Steve Lepowski of Ruderware in Wausau, Wisconsin, Matthew Hall of Schwab Attorneys in Sydney, Australia, Robert Lands of Howard Kennedy FSI in London, England, and Alison Williams of Mahans Attorneys in Johannesburg, South Africa. So we have a great presentation for you today, but before we get started, I wanted to walk through a couple of housekeeping items. As you've likely noticed, your phone lines are muted, but we do encourage you to interact with the presenters using the chat feature on your screen. So you can type in a message and that communication will go directly to them, and they will be answering all questions at the end of the presentation. Should you be experiencing any technical issues, you can hit *0 on your phone and you will immediately be connected to someone to offer you technical support. With that, I'll turn the webinar over to our presenters. Steve, are you ready to get started?
I am. Thanks very much, Kim. Thanks to everybody in the audience for joining us today. We are pleased to have the opportunity to present on a topic of great interest that we are sure everyone's going to hear a lot more about in the coming months and years. 3D printing may sound like the stuff that science fiction is made of, but in reality it's very much part of the here and now. In fact, President Obama mentioned 3D printing in his State of the Union address to the nation on February 12th of this year, noting that the industry has, quote, the potential to revolutionize the way we make almost everything, end quote. Others have described this as the sequel to the Industrial Revolution. Is this hyperbole on the grandest possible scale? Where will it actually end up? Well, we'll see. But the intellectual property and broader business implications of this technology are really just now coming into focus. This webinar hopes to provide both the U.S. and global perspectives on these issues and how the law may come to deal with the challenges, which will surely affect a wide range of industries and businesses of all sizes. Our webinar today will first provide an introduction to help orientate you to the current state of 3D printing and just what this fascinating technology is capable of. Then we will have a discussion where our panelists will consider a range of issues concerning how the legal community and the business community will need to deal with the implications of this technology. As Kim mentioned, we'll plan on saving the last 5 minutes or so of today's webinar for questions from the audience, so please do use that digital chat feature, and we'll get to as many of those as we can at the end. With that, I'd like to turn our presentation over to Matthew Hall from Schwab Attorneys, who's joining us in the very early morning hours in Sydney, Australia. Matthew is going to provide us an introduction to the fascinating world of 3D printing technology. Matthew.
Thanks very much, Steve, and good afternoon or good morning or good evening to wherever you are in the world. I just wanted to set the scene before we launch into a discussion of the challenges facing intellectual property practitioners with the developments of 3D printing, because I think it's important that we all understand what it is we're actually talking about. In September of last year, the Economist magazine ran a feature article about 3D printing and its potential impacts on the economy and on the law. And as demonstrated in the quote that is on the slide presently, it posits a thesis that 3D printing may well rewrite the rules of manufacturing in the same way that the PC had an impact on the traditional world of computing. And if that assessment is correct and comes to pass, then it will have significant implications for manufacturers and intellectual property rights owners as they struggle to control those rights And also, in the same way that the music industry has struggled with the challenges of digital musical files, the businesses that will succeed in a new world of manufacturing that's dominated by 3D printing will be those businesses that embrace a business model, I think, that recognises the reality of 3D printing and deals with it in some way rather than simply trying to bury your head in the sand and ignoring it. So what are we talking about? Well, at its simplest, we're talking about the use of digital technology and digital files to make a three-dimensional solid object that can be virtually any shape, that uses sequential layering of material being laid down by a printer to form the shape. So it's an additive process whereby micro layers upon layers are passed through a device to form the shape of the object that is to be printed. So it's unlike most traditional manufacturing or machining techniques which rely on the removal of material by cutting or drilling or other subtractive processes using dies or moulds. And it's actually been around for quite some time, for nearly 20 years, but it's now only beginning to hit the radar of a lot of manufacturers and also a lot of consumers. The term was coined at MIT in the mid-90s when two graduate students modified an inkjet printer to extrude a binding solution onto a bed of powder rather than ink onto the paper, and then proceeded to obtain patent protection for that development. So what the process allows is for someone who has the necessary hardware and software to create almost any shape or geometric feature. And the slide that you can see at the moment shows examples of articles that have been printed using 3D printer technology. So it can be used in the manufacture of jewellery or footwear or spare parts or building materials or formwork for building materials, civil engineering applications, motor vehicles, aircraft and aerospace applications, dental and medical industries, weapons, and the most recent development is the printing of food. So it has enormous application, and I think will have enormous impact. What it allows for is certainly in relation to design, it allows for rapid and easy and cheap prototyping of products. It allows for rapid and relatively cheap manufacturing of products, and it allows for very easy mass customization and even mass commoditization of products that might be difficult to come by or that might not yet presently exist. Several weeks ago, there was an article whereby someone had using 3D printer technology, they designed and printed a iPhone 5 compatible docking plug for their sound system. This enterprising person had bought an iPhone 5, and as anyone who has an iPhone 5 subsequently discovered that none of the accessories that have been made by Apple to date are compatible with the iPhone 5 because they have a different input. And so all of his systems and hardware was not able to be used, and in particular his dock to play his music, he couldn't dock his phone. And so he designed, using computer-assisted drafting, a fix for that problem, and then he printed it and then used it. So the challenges are here and now, and it's I don't think it's something that we're able to continue to ignore or hope will go away. So the process begins by the creation of a virtual or digital blueprint, and that is generated by computer-aided design or CAD software or animation modelling software. It can be something that is created from scratch, so it can be an article that is designed by the person wanting to print it, or, and this is probably the most significant issue for our present purposes, it includes the ability of copying an object from an existing object using a digital scanner that is able to record the three-dimensional measurements of the article from various angles and then turns that data into a CAD file. Once you have the file and the virtual blueprint, the printer will read that digital blueprint, and by slicing it into cross-sections and then depositing the manufacturing material, whether that's a liquid or a powder or a sheet material, will gradually, layer upon layer upon layer, build up the article until it is complete. And at the end result is that you will have a three-dimensional, real-world replica of the virtual model created in the digital blueprint, and that replica of the virtual model and the virtual model is almost identical to the physical article. And what you can see on the screen there is both an image of the program running in terms of the creation and modelling of the digital blueprint, and then the original article and the 3D printed article of a Viking belt buckle that was printed for archaeological archiving reasons. And it's probably a bit difficult to tell from the size of the photo on the slide, but the original belt buckle is on the left and the 3D printed buckle is on the right. And as hopefully you'll be able to see, they are virtually identical. I suspect if you saw the 3D printed article, you would be able to tell that it was not the original, but certainly from the photograph it is identical. And in my view, this technology is a revolution waiting to happen, and I think it will be more significant than the introduction of photocopiers, or more significant than the introduction of video recorders or digital video recorders. Over time, since the mid-1990s, the ease of use of machines has increased significantly and their prices dropped substantially. Whilst at the moment the level of interest and use is similar to that of the PC market in the 1990s, in that it's limited to hobbyists and enthusiasts, as the technology becomes easier to use and again drops in price, it will gain wider use and will become as disruptive as the photocopier or the PC. And the issue will then be how incumbent manufacturers and rights owners react to that, and what they do to either reject or embrace the technology, and how they can, and if so, whether they should enforce their existing intellectual property rights, or whether they will seek to lobby for change to introduce new protections, whether they will respond like the music industry responded to digital music, or whether they will respond in a way that's more embracing of the technology and more user-friendly. And so that's, I think, where we're at in terms of the technology as it stands, and where what today is to do is to try and get a sense of those issues around the intellectual property challenges that rights owners and users face as the technology continues to permeate the economy. So I'll throw back to you, Steve.
Great. Thank you, Matthew. And I think at this point it's helpful as we begin our discussion, our panel discussion, to give a brief overview of the substance of the rights that are implicated here. Intellectual property rights broadly fall under different statutes and different headings, of course. We're not going to spend a lot of time in this webinar talking about patent law, on the notion that if a particular invention is subject to patent protection and it is being reproduced on a 3D printer, in all likelihood that's going to be a pretty easy case of infringement. The more intriguing and I think more difficult questions come in the areas of copyright and potentially trademark as well, with the barriers to entry rather to having a particular invention patented, including the requirement of novelty and so forth. Copyright affixes from the moment a work of authorship is created, whether it's registered or not in the United States. And I think that's, if you're making a chair, it's obviously not going to be subject to patent protection. I think there are a number of analogous situations where the patent law probably is not going to be instructive, and again, probably not the focus of today's webinar. In the United States, we really look at a couple of areas, and I would start with the Copyright Act. And the critical notion under the United States Copyright Act is the extent to which a particular product that's manufactured using a 3D printer is capable of copyright protection. The U.S. Copyright Act specifies that there is a useful article is one that is intrinsically utilitarian, again, a chair. But the Copyright Act also recognizes the possibility that there may be separately artistic expressions within that utilitarian function. So, for example, a chair that has a carving on the back, or perhaps a floral relief design on silver flatware. The carving on the chair or the relief on the flatware may be copyrighted, but the design of the chair itself or the flatware cannot. That is the functional aspect as opposed to the artistic aspect. The difficulty becomes if you are trying to utilize the Copyright Act and understanding the limits of that, and this very difficult and sometimes murky distinction of where the useful article falls in either mechanical or artistic expression. It seems to me the Copyright Act as currently written poses a number of difficulties for manufacturers and rights holders who are hoping to utilize that as a tool as they protect their products from being reproduced in someone's garage or basement. Trademark law, I think, similarly has restrictions on functionality. There are a number of elements. A Coke bottle, for example, has significant design features to it that it is an indicator of source, capable as functioning as a trademark as well as a work of authorship. It's also copyrighted. But many functional products just don't have that that separate indicator of source in trademark law may prove to be problematic. I'd be interested at this point, Robert, where the law may differ as we get to a global perspective on this. If you could shed some light on the situation in the UK.
Absolutely. Yeah, I have the pleasure of living in one of the most complicated jurisdictions, I think, for this issue. We have some similarity with the States. As you say, patents could be applicable if what you're talking about is in itself an invention. You know, if you're reproducing a mouse trap, for example, that may infringe the patent for the functioning of the mouse trap. But mostly things will not be covered by patents because patents can't be used for the design itself. Here it's a question of copyright. If it's an artistic work, if it's a sculpture or a work of artistic craftsmanship, as we call it, but most of the time it's going to be a question of design right, which is something that I think you don't have in the USA. And in the UK, we have 4 different kinds of design right. We have a UK registered right that you have to apply for, like a trademark, a UK unregistered right that arises like copyright if certain conditions are met automatically. And then we have European flavours of the same thing, European registered and European unregistered. And they all have slightly different criteria for protection and different terms of protection, which I won't go into now. But most of the time it will be the design right that's at issue, not the copyright.
Okay. And I think as we listen to this, these global perspectives, I think are going to undoubtedly fuel the U.S. perspective as Congress eventually gets wind of what's going on in the marketplace and attempts to craft either changes to the Copyright Act or other intellectual property laws. I think what we're seeing in other parts of the world is going to be instructive. Allison, if you could, just give us a summary of where things stand in South Africa.
Sure, Steve. Insofar as copyright is concerned, the position is very similar to that in the United States, in that our law does protect the copyright in artistic works, what we term works of craftsmanship, but there is an exclusion for reverse engineering, primarily utilitarian articles that are made by an industrial process. So there would be a problem there for rights owners of useful three-dimensional objects to utilize copyright law. Very similar the position in relation to trademarks. You can get trademark protection in South Africa for shape marks, but you are limited in that the goods cannot, the shape can't result from the nature of the goods themselves, and the shape can't be necessary to obtain a specific technical result. So you also have the exceptions and the limitations under trademark law. Where we are very similar to the UK is that we do have a Designs Act, and you can register both functional and aesthetic designs in South Africa. The only problem with this is that you cannot register spare parts as functional designs. So again, you're getting the useful exception there. You can register aesthetic features of spare parts as aesthetic designs, but our courts have recently held that it's very unlikely that a spare part is going to have an aesthetic feature that is capable of registration as an aesthetic design. And then lastly, we have quite a broad and comprehensive Counterfeit Goods Act that would assist in preventing the counterfeiting of goods in respect of which there's a registered trademark or a copyright.
Okay. And Matthew, if you could shed some light on Australia as well.
Well, just to add to a layer of complexity, Australia is a little bit different to each of the jurisdictions we've just discussed. In terms of copyright law, copyright's not going to be very useful for rights holders in Australia. The Australian policy position is that an artistic work that is industrially applied, and it's deemed to be industrially applied if more than 50 articles are manufactured. So an artistic work that is industrially applied loses copyright protection. It is not an infringement to reproduce that article, either by reproducing the article or reproducing a two-dimensional representation of the article. So, whether it's plan-to-plan copying or article-to-plan copying or article-to-article copying, copyright protection will be lost. And unless it is a quote-unquote work of artistic craftsmanship, which might be something that would protect, to go on your examples, the types of design work on the back of the chair. The Parliament has said you can't rely on copyright protection, you have to rely on registered design protection, which gives the exclusive right for a maximum of 10 years to make an article embodying a novel and distinctive shape. The issue for designs, for what we're talking about, is that the exclusive right is the right to make and sell. Currently, there is nothing in our Designs Act that would cover the provision of a digital blueprint for the article that allows someone at home to make. So the provision of the tool that facilitates the making is not an infringement of any of the exclusive rights comprised in the registered design. So whilst the home consumer would infringe the design registration by running the program and making the article, the provision of that plan, as the law currently stands, would not infringe any rights. Our Act does provide that the provision of a kit that can be made into an article is also an infringement of the design, but I think there's a very real difference between, and the wording in the legislation is a kit, and I don't think our digital blueprint qualifies as a kit under our law. The other area that is probably going to be relevant is in terms of trademark and also trade dress and common law trademark rights. And what we have in Australia is a provision that prevents someone from engaging in conduct in trade or commerce that is misleading or deceptive or likely to mislead or deceive. And so it will be a question of whether or not articles that have a substantial market reputation, certainly if they're printed and then enter the market for sale as opposed to printed for private use, whether or not a consumer would be misled into thinking that 3D printed article was the same or from the same source as or of the same quality as an original article, irrespective of whether or not there was shape trademark registration for it or not. The way in which a seller would get around that, however, would be to simply clearly and unambiguously provide that it is a copy and a replica. We've had some litigation here recently involving replica furniture, whereby the sale and promotion of the replica furniture clearly as replica furniture did not infringe any either registered trademark rights or did not amount to any misleading or deceptive conduct.
Matthew, I find that interesting. As just a follow-up on something that you had mentioned, this private use notion. In the United States, under the Copyright Act, we do have a fair use section, which, my experience has been that many times people who just don't want to ask permission for using a copyrighted work just attempt to shape it into fair use. But the statutory section is fairly specific, and there are a number of factors, including the purpose and character, the use, whether it's commercial, and the effect of the use on a potential market or value for the copyrighted work are critical elements that a court will look at in terms of fair use. But we don't really have something that's specifically, if you're going to manufacture this widget for your own personal use at home, that this is somehow exempted from the Copyright Act. You you mentioned it in the context in Australia. I would ask Alison, is there something from a private use angle which, South Africa would be more like the United States or perhaps a different route?
It would be, but I think it takes it a bit further in that our laws stipulate that you can reproduce an artistic work if it is for what we term fair dealing. But our case law has said that the economic interest of the copyright owner should not be adversely affected. So in my view, if you were going to print objects at home with a view to doing that rather than purchasing objects and paying the owner of the right, that wouldn't fall within the definition of fair dealing. And insofar as patents and designs are concerned, we don't have any distinction that's relevant for these purposes for private use or personal use as opposed to commercial use.
Okay. Robert, you had a thought you wanted to contribute?
On that fair use point, we don't have fair use in the UK for copyright. We have fair dealing as in South Africa, but it has to fit within certain categories. So, for example, it has to be fair dealing for reporting of news and current events, and that wouldn't apply here, and none of the exceptions would apply here. So the copyright law doesn't have a general exception that says private and domestic copying is okay. In fact, it's actually still illegal in the UK to rip your CD into iTunes, and 99% of the population don't realise that. But conversely, on the design right point, we do have an exemption for private and domestic use. So the design rights which would be more relevant here wouldn't be infringed if you were creating something in your own home, as long as you don't sell it to other people.
And I think in the U.S. the approach has been, again, the Section 107 of the Copyright Act specifically relates to fair use. And again, my sense is that this is the most overused, inappropriately used section of the Copyright Act. The listed examples includes for criticism, comment, news reporting, teaching, scholarship, research, and so forth. And then there are a number of factors. The notion that someone just doesn't want to go to buy this widget at the store and has the digital technology that they can feed into their printer at home and make it in the garage doesn't suggest to me that that's somehow fair use. Now, recall, though, that that does not overcome the limitations on copyright in general. And the limitations on copyright in general are, is it functional? And if it is, then apart from any singular aesthetic element of it, it's not going to be protected by copyright. I think there's still a significant hole, even though fair use is not going to be something that's going to just offer a truly copyrightable work protection for the individual users, whether they sell it outside their home or not. Matthew, I wanted to follow up, if I could, just on the digital blueprints concept. You had articulated, I think in Australia, that the reproduction of the digital blueprints or the instructions for the 3D printer would not actually be protectable. Is that did I understand that correctly?
No. What I was trying to say, Steve, was that the provision of the 3D blueprint by a commercial supplier to an end consumer would not infringe any registered design right in the article that was able to be printed from that blueprint. Certainly, under Australian law, the digital blueprint itself will be a copyright work, protected as a literary work, as a piece of computer software. And so even a blueprint that is a slavish copy of an existing article will be a separately protected copyright work. Our threshold for originality for copyright protection means that whilst there needs to be some skill and judgment involved in the creation of the work. But I think that you would be able to establish that the positioning of the article and the use of a scanner and other elements would be sufficient to give that originality. Pardon. And so there will be a separately protected copyright work in that blueprint, which would be owned by the creator of the blueprint, who may well be a pirate or a provider of replica product. So no, it certainly would be, the blueprint itself would certainly be the subject of copyright protection here.
And I misunderstood that, because I think that comports more with the U.S. notion of if I'm a manufacturer and I'm concerned, one of my possible avenues is to safeguard the digital blueprints, but technology being what it is, if the functional element or functional product which I sell is out in the marketplace and being purchased, someone's going to create their own digital blueprint. They're not going to have to find my version of that digital blueprint and copy it. And again, a critical concept for copyright is the idea that underlines the actual work of authorship is not protected. So if someone can purchase the functional item and manage to deconstruct that and create the data necessary to feed that digital blueprint into the printer, they really haven't done anything wrong under that scenario in the United States. And I think that presents an enormous challenge as you're looking again at these avenues for an unpatented product. How are we going to stop this? I think the Copyright Act as written in the U.S. has some significant holes in it. I wanted to shift gears just for a moment. I think we may have touched on this just a moment ago, but I'll ask Robert to comment in the UK. If you look at this from a slightly different perspective and you think about the printing machines themselves, are they illegal in the UK as functioning mainly for the purpose of copying allegedly articles or facilitating infringement? Is there some sort of contributory infringement concept that might be extended to the manufacturers?
We do have that concept. It's known here as authorization. You can be liable for authorizing the copyright infringement. But actually, I'm pretty certain that the machines wouldn't fall into that category and they would be legal because there was a case in the 80s that involved a manufacturer called Amstrad that was sued by CBS for producing a twin-deck VCR machine where you could copy one tape to the other. And the court said essentially that because there are legitimate uses of the machine, someone could use it to duplicate their home videos, the machine itself shouldn't be illegal and the manufacturer shouldn't be liable unless they were promoting it specifically for the purposes of copying commercial tapes, which they weren't. And the same would be true here, because you could use a 3D printer to create your own creations. It doesn't have to be only used to copy stuff. So I think it would be fine actually to sell the machine here.
And my guess is, and we'll touch on this as we get further on in the business response and legislative response. My sense is in the United States that is one of the avenues where rights holders who have a lot on the line may look to push the boundaries of the Copyright Act, and that's on the contributory front, contributory infringement front, and how that may implicate people who aren't in their garage at home making widgets for their own personal use, but who are the companies who hold rights in printing machines and are allegedly facilitating the infringement by merely selling those. Alison, is there a treatment of this in South Africa that might be instructive?
Yes, Steve. In terms of our common law, our courts recognize the act of contributory infringement, and in my view, I think that there could be a case in delict or tort, as you would say in the U.S., for contributory infringement in relation to the printers themselves.
Okay.
And also in relation to supplying a digital image, that could also be a contributory infringement.
And that's a great point, Alison. I think if you're the individual running the file-sharing website that is specializing in this type of digital blueprint for various products, if you're doing so without the authorization and certainly without some stream of revenue back to the manufacturers, my guess is that whether the claim stands in the United States under the contributory infringement principles or not, my guess is that there will be pressure exerted on those people as a means to try to put the clamps on at least those areas where manufacturers aren't able to control that. That's speculation.
That's right. And if you look at, for example, Thingiverse, they're quite passive in the way they deal with intellectual property right protection, and they encourage the users to make sure that they're not infringing intellectual property rights. But if it was here, they would have to go a lot further to allay any claim of contributory infringement.
Matthew, a concept similar to this in Australia?
Yeah, well, there's certainly a concept of authorization in terms of copyright law. So if there was an underlying right that was being directly infringed, a person who provided the means for and the ability to control that copying would be liable. So, for example, and it's very, very similar concepts to what we talked about. So, the provision of a photocopier in a university library amounted to authorization of unauthorized copying of literary and artistic works on that photocopier by students at the university, and the university was liable for that copying. And similarly, in the Kazaa peer-to-peer file sharing litigation that occurred both in the United States and here, because the Kazaa operator was an Australian resident entity, the court found that the provision of that peer-to-peer file sharing software, which was only for the purpose of allowing the illegal and unauthorized copying of digital musical works, amounted to authorization. But the main problem under Australian law would be that there will be no primary direct infringement of any copyright work unless what is being printed is a work of artistic craftsmanship, and that is highly unlikely, I suspect.
Mm-hmm. I think with that, I'd like to shift this to where perhaps the most interesting and speculative discussion is going on, and that's really related to the business and legislative responses that can be expected from this. Again, the technology is not, as Matthew mentioned, is not brand new, but it is certainly now being commercialized in a way that has not been before. Congress in the United States, if they're aware of it, is certainly not looking to act quickly. My guess is that while case law will try to retrofit the Copyright Act to the technology as this moves forward over the years, there's going to have to be some type of U.S. congressional response, some legislation, and much the way that the Digital Millennium Copyright Act was created in light of the proliferation of the Internet and this sort of resulting assumption by Internet users that if it's posted online, it must be available for my use without attribution or payment or permission from anyone else. I think that exemption sort of process with the Digital Millennium Copyright may take shape in the U.S. My guess is also on two fronts, really. If rights holders are looking to make headway in the U.S., my guess is they will pressure those that they see as contributory infringers rather than trying to find John Q. Public in his garage making a chair or a coffee cup. They're going to go after the parties that can help them control the process by which this goes out. And we'll touch on that in just a second with another question. I think the second point I see in the U.S. is I expect a strong push in the Copyright Act to change the definition. If you recall, we talked at the beginning of the webinar that useful articles may contain an artistic element, the design feature on the back of the chair, as well as the utilitarian element, the chair itself. My guess is that rights holders will seek to broaden that definition so that any chair that contains a useful element and an artistic element could be subject to copyright protection. If you can push that boundary further by changing a critical definition under the Act, I think rights holders would face a dramatically different landscape, and the Copyright Act suddenly becomes a much more viable tool. I'd be interested in any crystal ball type forecasts that you might have, Robert.
Well, I don't know that I've got the answers, but I think there could well also be changes here. I think there would be lobbying by manufacturers to try to get rid of the private non-commercial use exemptions under design right law. But it would be difficult because it is, as you know, the US learned with the attempt to introduce SOPA. It's very difficult in the current climate to strengthen IP laws. The type opinion is going the other way. In fact, I mentioned about the UK not having a private use exemption for copyright, and actually, although that's always been the position here, it's going to change before the end of this year, according to an announcement that the government has made. I think the key may be in trademarks, actually, in the value of an article as being original from the manufacturer. I think that may be what manufacturers will have to do in order to combat this, to try and increase the cachet of an original product.
Do you sense any type of significant UK response on the order of some type to either tax or levy or assess either the printers themselves as they're sold, or some other mechanism so that rights holders who may not be able to recover generally might find some share in this revenue?
Yeah, that's an option. There are levies like that in other parts of Europe already. In the UK, because we haven't had a private use exemption, we haven't had a levy, and the proposal to bring in the private use exemption doesn't include a proposal to bring in a levy, which has annoyed some copyright producers. So I don't know if they would bring it in because of the tide of opinion, but it would be an option.
I wonder too, I mean, we've touched sort of on the edges of this already, but the notion of this digital rights management feature, or these DRM systems that were applied to digital music files for years, and Apple had this originally. If you want to share or download something from iTunes, we're going to have this anti-piracy code embedded, and it's only going to authorize sharing with authorized users or by authorized parties. Are manufacturers better off seeking this type of approach, this limiting approach to how these files, these digital blueprints can be shared, or are they better trying to seek some type of manner where they can control how the public gets these, and whether it's through a music file sharing service sort of arrangement, but one that's run by the manufacturers or the industry themselves? I'm not sure what the answer is either, but Allison, I wonder if you had some thoughts.
Yes, I think my view on this is it's very much, it's dependent on the industry and the consumers involved. I don't think you can have a standard answer to this. I would say you'd have to balance what your consumers want and the risk of losing consumers to competitors to protecting your IP rights. And you discussed earlier an example of Nokia who had agreed to allow people to 3D print cases for a Nokia phone. And I think an approach like that, where you allow 3D printing in relation to perhaps a non-key aspect of your product, would be a good way to go, and sort of keeping customers happy and at the same time still getting the protection for your fundamental and most important primary IP rights.
Allison, I'm glad you brought that up. It's true. Nokia in January of this year, it actually issued a press release indicating that they will let their owners use 3D printer to make their own cases for Lumia branded phones. And Nokia's sort of response to this is that we're offering this. It's going to be much more customizable to you, the consumer. And I'll read you just a brief quote from one of their representatives. It reads, quote, "You want a waterproof glow-in-the-dark phone with a bottle opener and a solar charger? Someone can build it for you, or you can print it yourself," end quote. So they've captured this notion of our product made better by you, or at least, again, the distinction being the case as opposed to the phone. And as we spoke offline, Allison, I think you correctly noted this would be very different if Nokia was actually opening up the book, so to speak, on the operation of its actual phone. But capturing that sort of marketing angle of we're willing to offer this to the users in exchange for what we hope will be some brand loyalty as we move forward. And I don't know what the right balance is, and you're probably right. It's a case by case sort of anticipated basis, but it'll be very interesting to see where this comes down as things go forward. I'm probably one of the people that worries whether the legislative responses that companies are going to be hoping for will actually create more problems and questions than they actually resolve, which wouldn't be unusual in the United States. But
just on the point of legislative involvement, South Africa has recently passed legislation where the state acquires fundamental intellectual property ownership in relation to publicly funded IP. So even though there's nothing at the moment, I think that there would be some incentive for our government to amend our legislation, to particularly the Copyright Act, to provide stronger protection against 3D printing.
I think there's likely to be a range of options that rights holders are going to look at. I've given some shot-in-the-dark sort of predictions on where this might go in the U.S. Matthew, just as sort of a way to round this out, did you have some thoughts from your perspective on this digital rights management as a solution for manufacturers attempting to gain some control as 3D printing takes particular relevance?
It certainly is an option available to them. I think that the greater challenge, though, will be as not only the printing technology improves and comes down in price, scanning technology will be as well. So the fact that I am making my quote-unquote legitimate product available as a digital blueprint and as a secured blueprint with digital rights management applied won't stop someone from acquiring the article and scanning that article and creating their own 3D blueprint. So I think it's probably a bit of a false hope to think that the solution for rights holders in articles is to control the digital blueprint, when the ability to turn an analog article into a digital blueprint and a series of ones and zeros is going to become increasingly easier to do. I in fact think that the digital rights management issue is something that is also important for people who are making so-called unauthorized copies of the blueprint available, and how they can control the market. The only other comment I'll make is that I think probably rights holders should look very carefully at what happened in the digital music space, and I think they will find that consumers are more likely to embrace a response and embrace a product where the response is probably more inclusive, rather than going down the way of litigation or enforcement or creation of additional rights. I just make that as a sort of an aside.
Sure, and my thought would be, you may see some small sample of litigation examples being made of particularly egregious offenders, coupled with the notion that if you don't want to face what this particular individual is facing, then visit our website, which we sponsor and where we authorize certain limited uses of our digital blueprints for a wide range of our products. You may see some combined strategy here, and it wouldn't surprise me if it was industry-specific strategy too. Each competitor may be looking for assistance that helps the group, collective action through industry or trade association action, much the way the recording industry started to do after they learned you just can't stop every one of these users at the root level by getting into their living rooms or homes and investigating what potential responsibilities they have as individual users. We're running short on time. We've only got a few minutes left. I realize there are a host of issues that we've not had time to talk about today. For example, one that has come up in my head about particular interest, not IP related, but just product liability concerns. You can imagine the entire range of issues if you make a bicycle helmet at home on a 3D printer, which fails at the moment of truth and causes injury. Who's responsible? The manufacturer of the helmet, the digital blueprint, the party that made the 3D printing replica, or the manufacturer of the 3D printer. I mean, who knows what other issues on non-IP related questions may come about. But we hope that the webinar has given everyone here an introduction to what's likely to be an issue affecting more and more of our clients as we move forward. We're looking through and don't really have questions at this point submitted through our chat feature. And with just a couple minutes left, I would like to thank everyone for their time. We certainly appreciate it. If you do have any questions, I guess this would be the final call for that. But in absence of those, we appreciate again the opportunity to speak with the audience today on a fascinating topic, and we'll see absolutely much more of this as we go forward, and look forward to keeping up with the events as they unfold.
Steve, Robert, Allison, Matthew, thank you so much for sharing all of your knowledge in this area. Definitely going to be a lot more to come on this topic, and we'll definitely be looking to all of you as a resource for us. With that, if we don't have any further questions coming in, I just wanted to alert everyone that you will receive a copy of today's presentation, as well as a link to the recording and a short survey coming out within the next couple days. So we appreciate any input you're able to provide. We also encourage you to continue to reach out to our presenters if you have any ongoing questions or if anything comes up. So that's Steve or others. Is there anything else you'd like to share?
Kim, I think we did get just one question here. I'll read this for the group and allow anyone here one of the panelists to respond. The question is, what is the concern with aggregating blueprints submitted by users and publishing them for public use? And I think the question, if I understand it correctly, in aggregating blueprints is if that means pulling together blueprints from separate sources. In the U.S., I'm not sure that taking those from separate sources submitted and publishing them for public use, I'm not sure that publishing them for public use necessarily on an aggregate basis would be a problem, other than if there is some fair use defense for this, such as it's purely non-commercial, it's part of a research article, or it's something else. I'm not sure that there would be any claim for that. I don't know if anyone else had thoughts on that question?
There would be a claim in the UK. It would infringe the making available right. And you could, as a rights owner, you could take action against the website for hosting it, and also against people's ISPs, Internet Service Providers. You can get an injunction under our Digital Economy Act to make the ISP block access to the website that's doing that.
And I think there would also be a contributory infringement claim in South Africa, in my view.
I think we may.
And in Australia, I mean, we've got the somewhat, people might think, perverse position whereby the article itself isn't able to be protected by copyright, but if the rights holder produces their own digital blueprint and then someone, rather than scanning the article, they copy the blueprint, that will be an infringement of the rights in the blueprint. And the copying of that blueprint and also the making available to the public in the same way that Robert mentioned would be an infringement. And you may well also be involved in authorisation.
And I think there's certainly in the U.S. The notion is going to be entirely dependent on how that is published, whether it constitutes fair use because it's part of a scholarly article or news reporting. That would be a very different situation from somebody who runs a commercial website and profits from the notion that they're aggregating these blueprints and sharing them for profit. So with that, I think without any other questions, thank you all once again. And Kim?
Great. Well, I think that's it. Thanks everyone again for participating. And again, thanks to all of you presenters for sharing all of your knowledge in this area. Hope everyone has a wonderful afternoon, morning, or evening, depending on where you're connecting from. Take care.
Thank you.
Thank you. Please stand by.